Hi, Dennis Lyon with HomeServe. I'm the Regional Director for the National League of Cities Service Line Program, also endorsed by the League of Oregon Cities. Do you know who's responsible for repair of the water and sewer lines on your property? Surprisingly, many people don't until they have a problem, call the city, and are told it's the homeowner's responsibility. The NLC Service Line Program partners with communities to proactively educate homeowners on that responsibility while also offering them affordable voluntary protection to guard against costly repairs. All repairs are made by local licensed and heavily vetted contractors, and we pay the contractors directly for their services. There's also an optional revenue share component that can provide funds for city initiatives. The NLC Service Line Program is available at no cost to your city. Currently, there are 16 Oregon cities participating, and I hope you'll reach out so we can discuss how our program can benefit your community as well.
Hi, everyone. I'm Lisa Sornin, Executive Director of the State and Local Legal Center. The SLLC files amicus briefs in the Supreme Court in cases affecting state and local government. The Oregon League of Cities is a member of the SLLC through the National League of Cities. I'm very excited to be here with you today, a little bit early, albeit in the recording, to talk to you about issues for cities related to protests. I'll mostly be focusing on the First Amendment, but I'll talk about some other issues as well. Before I begin, I want to thank the following people on this slide whose materials I relied on to put this presentation together. So now let's begin. The protests following George Floyd's death were very extraordinary in many of the ways listed on the slide. And of course, we've had many more protests in this country since then, related to the death of Jacob Blake, and now today, related to the officers in the Breonna Taylor case not being prosecuted significantly. So if we were meeting in person, I would ask you all to raise your hands about whether you live in a small town, whether you had a protest, and whether you attended it. I think that the statistics show that more Americans have been protesting now than since the 1960s. So the right to protest in this country is treasured. It is in the First Amendment to the US Constitution, which focuses on not allowing the abridging of free speech and allowing a peaceful right to assembly. So I realize that the First Amendment talks just about Congress, but the Supreme Court has interpreted it to also apply to state and local government officials. And this is actually a double-edged sword. That's because local government officials must protect / not violate people's First Amendment rights, but they're also in some instances protected themselves. So there are 3 Supreme Court cases, one of them from Oregon, which sort of lay out the framework and the foundation for the Supreme Court articulating standards underneath the First Amendment. I am, however, going to spend a lot of time in this presentation talking about the Ninth Circuit. The Ninth Circuit is a federal court of appeals. It's underneath the Supreme Court, so cases from there can be appealed to the Supreme Court. It covers California, Washington, and Oregon, and has produced a ton of cases on protests. So here's basic First Amendment analysis. First, you have to figure out, is the speech or conduct protected by the First Amendment? Protesting peacefully is protected by the First Amendment. Then we have to look at the nature of the forum. This determines the extent to which governments may limit speech or conduct. Most protests take place in what's called traditional public forums. This is a place where protesters have the greatest rights to protest. Then we have to look at if the government is restricting speech, whether the government is able to meet the standards that the Supreme Court has articulated for restricting speech. In a traditional public forum, those restrictions are as follows. Government restrictions are okay if they're content neutral, if they're narrowly tailored to serve a significant government interest, and if they leave open ample channels of communication. The slide is really important. I'm going to go back to these concepts over and over again throughout this presentation. So here's the bottom line. Citizens basically have a right to protest that's close to unlimited, but not totally unlimited. They can mostly say what they want, but they must protest lawfully and peacefully. And protesting wherever and whenever they want gets a little more complicated as well. There are some limits on the type of speech that is protected by the First Amendment. But when you look at this list, most of this stuff is not going to come up during a protest: blackmail, child pornography, etc. So the main limits when you're talking about protests are actually on the government. The government cannot simply disallow protests, can't disallow protests based on the content of the message, and again, must be able to justify any restrictions on time, place, and manner according to the standards articulated by the Supreme Court. So for the rest of the presentation, I'm going to do the presentation instead of a Q&A. I'll be asking the question and answering the question. So the first question is, may protests be stopped ahead of time? Generally, the answer to that is no. There is a Ninth Circuit case on this that says protesters would have had to have previously acted illegally, or there has to be some demonstration of a clear and present danger. So what if you don't like the message that the protesters have? Well, as I've already said probably 3 times, because this is the most important point to make in the presentation, that restricting speech based on content isn't okay. So especially if you don't like the message the protesters are making, you have to allow protesting speech, even if that speech is offensive. Justices have recognized this concept of the heckler's veto. It's the idea that someone could complain about any sort of offensive speech, and if we allowed that to stop speech from happening, there wouldn't be much speech going on. So there is no heckler's veto, the Supreme Court has said. People can make offensive speech, and if people don't want to hear it, that's too bad. So it would take a lot to stop a protest ahead of time. And in fact, there's even a Supreme Court case on this. This case out of Indiana involved a guy who said, with some obscenities, I'm basically coming back again tomorrow. And the court said, not only can you say that, you can do that. You can come back tomorrow, even if no one wants to hear your message. So the next question is, may protesters be required to obtain a permit? There's actually a lot of case law in the Ninth Circuit on this issue, and there are 3 general principles that can be gleaned from the case law. The first one is that permits should not be required for events that don't have implications for public safety or for use of the public right-of-way. Localities have to make some sort of provisions for spontaneous protests, and permits should not be permissible when the group is small. So in the Santa Monica Not Bombs case, Santa Monica's policy said that a spontaneous protest could happen at the town hall within 48 hours of a newsworthy event. And the Ninth Circuit said that was okay because it would the city hall would accommodate large groups, and that the 48 hours was a reasonable amount of time to not ask for a permit. In the Long Beach area Peace Network case, Long Beach's policy said if you wanted to have a spontaneous permit or protest, you had to offer 24 hours of notice. And the court said that that wasn't okay because what if your protest didn't involve any traffic problems at all? And there was no other means to protest other than getting a permit within the first 24 hours of something big happening. The last case I'm going to mention in this space came from Fresno. Fresno had a policy that you had to get a permit if 10 or more people were gathering. And the court said that number is just too low. I would suggest not asking for permits for groups under 50, based on the case law that I've read. I forgot to mention at the beginning, I'm also going to occasionally pull up what ACLU says about these issues. I agree with most of what they say. I think they read the law pretty accurately and pretty correctly. In some ways, maybe even more generously than I do. For example, they say that on this slide, if you're going to have an amplifying device, you should be able to, or you should, it's okay if a city requires a permit. I never saw that in case law, but it seems pretty reasonable. So I'm not going to spend a lot of time on these ACLU slides, but even though ACLU has its own angle on these issues, I do think their legal advice and their legal information is actually pretty accurate. So the next question is, when are permitting requirements allowable? Again, they have to be based on reasonable time, place, and manner restrictions. A restriction is reasonable if it doesn't give government officials too much discretion, it's content neutral, narrowly tailored, and leaves ample channels for communication. So like I said, it's the theme of this presentation, content-based is the most important thing. restrictions in permits cannot be content-based, and there's actually a great case from the Ninth Circuit that illustrates this. So in Seattle, if you wanted to have a protest on the street rather than on the sidewalk, you had to get a permit. And the police chief had complete discretion whether he would assign you to the street or assign you to the sidewalk. Well, everyone wants the street, you know? And so what would happen as a practical matter, because he had complete discretion other than traffic safety, he would give the more controversial groups the streets only if they had big numbers. But if it was a less controversial group, he would give them the street even if they had small numbers. So the court said, this police chief has way too much authority. His only discretion is safety, but you know, anything on the street is going to involve safety. And the policy didn't give any reasons, any criteria other than safety for him to consider, and who got a permit for the street and who was forced on the sidewalk. You can contrast with the Long Beach Area Peace Network case. In this case, a group had to have 3,000 people protest in a relatively small city. And the city said, per our policy, we're going to tell you where you can protest and what route you have to go on. And they protested, filed a lawsuit, but their policy had tons of criteria that the city manager had to look at all these factors to decide whether the route and the location it picked were okay. And the court said that that policy was constitutional. So can you require notice to obtain a permit? Courts have generally said yes, the Ninth Circuit included. The reason why cities need notice is obvious to you. You need to be able to make sure you have the police officers working the right shifts. You need to be able to move traffic around. But the court has said it shouldn't be too much notice. The Ninth Circuit has said 2 days notice before a permit is not too much to ask. But there's a district court case that said 5 days was too much time. Now, this was a protest that only involved 10 people. But courts have struck down 25 days, 30 days, etc. May we charge a fee? Yes, but the fee cannot relate at all to the reactions of the listeners. So get this, you can charge protesters a fee for trash cleanup related to their protest, for policing related to their protests, but you can't charge them for trash pickup related to counter protesters or police presence related to counter protesters. How in the world any city can figure out what is the cost for protesters and what is the cost for counter protesters? I have no idea, and the courts don't really say. But that's kind of where the line has been drawn. There's actually a Supreme Court case on this as well. So this county they said they charged everyone $1,000, but in reality, the county administrator could charge them whatever they wanted. And the Supreme Court said, no, that's not okay. You have to have some sort of criteria, some sort of explanation for why some people are charged and some people aren't, or why people are charged different amounts. Must or may cities waive fees? So courts have said yes, but if they waive fees, they have to do it on a non-content-based basis. So numerous cities waive fees for indigency, and that, of course, isn't content-based because anyone could be indigent, right? And the Ninth Circuit has also said that having no criteria for when fees are waived is not okay. So may the city require insurance of protesters? The answer is yes, per the Ninth Circuit. May the city require a hold harmless agreement? Again, the Ninth Circuit has said yes, but with some caveats. And this is a little bit complicated, so I'll stop to explain this. So a hold harmless agreement basically is a city saying, okay, if you want to have a protest, you're responsible for all the legal problems that arise during that protest. And so the Ninth Circuit has said is that that's okay as long as the protesters don't have to pay any costs related to the reactions of counter protesters, any acts of the city, or acts of third parties. So basically, cities can say, you protesters will be legally responsible for your own behavior, but you can't ask the protesters to be responsible legally for anyone else's behavior. In this case, this slide goes into more detail on that. So again, ACLU has a statement on this, which I'm basically in agreement. So when can we deny a group a permit? So the Supreme Court, again, has a case on this and has listed 5 criteria for when permits may be denied. If the permit application is incomplete or contains material falsehoods, if the applicant has destroyed property and not paid for it, if the group wants multiple spaces in the city, they can be denied multiple spaces. If the location they want will cause unreasonable health and safety problems, or if they violated prior permits. Again, the ACLU has some no-nos on permitting as well. So one of the more interesting questions, I think, is where can people protest? And the Supreme Court, as I said earlier, has adopted different rules for different forums, but mostly protests happen in traditional public forums. And in traditional public forums, again, we're looking at reasonable requirements, time, place, and manner requirements. So people can always protest on their own property. They can protest on private property with permission. And things get a little more tricky when people want to protest in privately owned public spaces. So you might wonder, can a city move protesters from the location they want to another location? In general, the answer is no. And the reason is because location for protesters is often a part of the message. However, if a group is really big, that can create an exception. So there's a very interesting case out of the Ninth Circuit involving the 1999 World Trade Organization protests. I even remember these protests, and they were 20 years ago. They lasted for days. There were tens of thousands of protesters, and sometimes the protesters got out of control and there was violence. So what happened is the city of Seattle, basically what they did is they moved the protesters to specific areas. So you had the hotels, right, where the attendees were staying, and then there was the convention center. So people could protest along that walk from the hotels to the convention center. But the protesters had many complaints, which is why they sued. They said, we want a bigger area. And the court basically said, well, you can see them when they're walking in and out, so that should be big enough. The protesters said, well, many of us were protesting peacefully. And the court didn't disagree, but said, you know, there's tens of thousands of you, and some of you are out of control, and we've got to do something about that. The court said that it was a close case as to whether the protesters had alternative channels of communication, but ultimately Seattle won the lawsuit. I would be careful about this decision. I would not use this myself to move protesters sort of willy-nilly. I think that this case really is extraordinary because there were tens of thousands of protesters and violence had ensued, but it's still like a pretty good ruling for a city authority. So you may also wonder, what rights do counter-protesters have? The Ninth Circuit doesn't have a counter-protester case, and in fact, most jurisdictions don't have counter-protester cases. So here I'm actually going to rely on the guidance of ACLU because I think it's pretty sensible. What the ACLU says is that counter-protesters have a right to protest, but they can't disrupt the original protest. And the ACLU also says that counter-protesters and protesters can be separated to some degree if they're not getting along, but they can't be sent really far away from each other because part of the point of being a counter-protester is to respond to the protesters. So that all kind of makes sense. There is a DC Circuit case where it was Ku Klux Klan and anti-Ku Klux Klan protesters. They had a long, acrimonious history. And basically the court said, if you're protesting and counter-protesting, it's gonna be a bloodbath. We're gonna cut back on what rights you have to protest and counter-protest. But like I said, most jurisdictions have not said much about this topic. So, oh my gosh, the protesters have guns. Can we take them away? So in Oregon, it might be possible to ask protesters to leave if they are armed. So the Oregon legislature allows local governments to ban people who lack a concealed carry permit to carry a loaded firearm in a public place. The law also says that you have to carry your permit with you if you have your gun. So police officers during a protest can ask people to see if this is the law of the land in the city, can ask to see their conceal and carry permit. If they don't have one and the firearm is loaded, they can be asked to leave. And but in general, Oregon seems to be a pretty gun-friendly state, but that's the one circumstance if there's an ordinance in place and the person lacks a permit, in which case guns would not be allowed. So are all these armed people engaging in unlawful paramilitary activity? So I have to be honest, before I prepared for this presentation, I didn't know anything about this issue, though I did see those guys in Seattle, or in Charlottesville, wearing kind of military-ish fatigues and guns, walking around like they were sort of police officers, and I kind of wondered, is that okay? So the long and the short of it is this. Most states have a paramilitary activity statute that bans this activity, but the activity the statute bans isn't very much and probably isn't going to help Oregon cities in protests. What the statute basically says is what's not okay is an assembly of people practicing with guns with an intent to unlawfully employ such firearm. So I think if you would have asked Kyle Rittenhouse, this is the guy who shot people in Kenosha, did you intend to unlawfully employ your firearm? He would have said no. And so, like, you don't really know someone intends to do that until they actually do it. So I don't see how the statute would actually be helpful in eliminating the paramilitary types who come to these protests. But other states have different statutes, and I doubt there's any litigation on this in Oregon. So the next question that's had a lot of litigation is, can we prevent protesters from sleeping outside? And the answer to this is, it depends. And we have a ton of litigation because this came up during the Occupy movement. And the general principles you can glean from the cases that arose out of California are, it's easy to defend a policy or an ordinance that disallows sleeping or disallows people at a park for a certain hours if there's notice provided, if there's clear realistic reasons as to why the park has to close or there's no sleeping during a part of the day, if there are alternative spaces for sleeping available, and if the ordinance hasn't just been used against protesters. So the first, or actually, there is a Supreme Court case on this as well. So a bunch of people were protesting homelessness and they wanted to put up tents, and they got permission to do that. And then they said they wanted to sleep in the tent, but these tents, they wanted to put them in Lafayette Park in Washington, D.C., which is a part of the National Park Service. The National Park said, we only allow camping in campgrounds. And the court said, well, we're going to assume that sleeping is outside as protected activity by the First Amendment. But I wonder if that would be true of people that are protesting police violence. I mean, I could see how in Occupy, by sleeping outside, you're making a statement, but sleeping outside to protest police misconduct, there doesn't seem to be any obvious expression there. Anyway, regardless, the court said, you know, this is a major park. Millions of Americans come to see it every year. And so it's possible for the Park Service to say no camping. Now, here's what happened in California as a result of Occupy. So protesters challenged a park ordinance that closed the park for about 6 hours. And the big reason why I think the city won was this ordinance had been on the books since 1981. So they obviously weren't going after Occupy, but there were other things too. The city said, you know, we need time to be able to clean the park. If you want an exception, you know, there's a process to sort of to gain one. Park Service has said we have limited resources to provide, you know, what the needs of this park are. The Fresno case is a little bit different because the people in Fresno didn't claim they wanted to sleep in the park. What they claimed was they wanted to actually protest in the park from 12 p.m. to 6 a.m. And the court said, no, you can protest on the sidewalks all night long if you want. That's still open to you. You can protest on the streets, they're still open to you. But the park does not have to be open to you for protesting 24 hours a day. So now here's the really big question. What if you are a homeless protester and you want to sleep in the park? As you all know, because you live in Oregon and you're in the Ninth Circuit has said that if a homeless person has no option of sleeping indoors, a city can't cite them. So I think with this ruling that probably you could say to a homeless protester, you and everyone else cannot sleep in this park, but you can sleep, you know, on the street, or you can sleep somewhere nearby. I think you'd have to give some sort of options for sleeping in a public place. But the Boise has added sort of another layer to this situation. Okay, so the next question is, what if protesters get out of control? Oregon has a statute that says that assemblies can be dispersed if there is an unlawful assembly or a civil disturbance or a riot. So if a crowd refuses to disperse after being told to disperse, they can be arrested. But Oregon statute's also pretty clear that they have to be warned first. So what is a riot? Oregon law defines a riot as basically violence with a number of people involved. An unlawful assembly or civil disturbance is not defined in Oregon statute, but the Supreme Court and the Oregon Court of Appeals has basically said it's like being on the threshold of a riot. That's what an unlawful assembly or civil disturbance is. What this might look like is people sort of taking steps to indicate they might be ready to engage in violence, like reaching for a gun, walking in mass in traffic, stopping police cars, stopping other vehicles, throwing things at police officers or bystanders, vandalizing and destroying property. Those are examples of what an unlawful assembly or civil disturbance might look like. So why can protesters be arrested? They can be arrested when there's probable cause that they have committed a crime. That probable cause has to be individual to them. And again, if they state a riot after they've been told to leave, they can be arrested as well. Mass protests provide some problems for cities, two problems in particular. The first problem is that often if you arrest people in mass, you don't have individual suspicion related to them. Second, if you arrest a ton of people, it can be hard to book them and get them out of jail quickly, which can also lead to the violation of their rights. So what amount of force during protests is legal? It's the same standard of force that applies in any other context. The Supreme Court has said force must be reasonable, and what the court looks at is the severity of the crime at issue, whether the person presents an immediate threat, and whether or not he or she is actively resisting or running away. So here's the deal. Those constitutional standards on force, they're not very specific. But if your city has a history of protests, you probably have much more specific policies and practices that your police officers follow. Okay, my favorite question of the whole presentation. May protesters record the police? The answer is unequivocally and absolutely yes. The Ninth Circuit was the first federal circuit to assume this right in 1995. That person must have had a camcorder back then. And then in 2013, the Ninth Circuit recognized the right. So yes, police officers can be recorded. So sometimes people wonder, why do police officers at protests wear all that scary gear? The answer from a legal perspective is that riot gear, which like I said, can look a little intimidating, may be required. But even if it is required, police officers can sort of hide it or put it away until they need it. The reason why it's required is basically OSHA. OSHA says, in simple terms, that people have to have the equipment that they need to do their job safely. And so it's the employer's responsibility to assess what that equipment is and to actually provide it. So that's why officers have to wear it. There's a very interesting lawsuit that was filed about 2 months ago out of Seattle. Protesters claim that their First Amendment right to protesting is being abridged because they cannot afford the gear themselves to deal with the tools that the Seattle police are using to break up protests. I personally think this lawsuit is going nowhere, but it's pretty interesting and it shows the range of issues that can come up during protests. So the next question is, can officers be successfully sued for failure to intervene when a protest turns violent? I think that in most instances, the answer to that is no, except perhaps in the Ninth Circuit in two particular instances. Those are the state-created danger and the fellow officer exemption. So the state-created danger exemption is basically this. If the police or government officials create something dangerous themselves, they can be sued when bad things happen to people as a result of that danger. In the protest situation, this is the example I could think of. There's a bunch of peaceful protesters. Police officers direct them, for whatever reason, to walk in the direction of unpeaceful protesters, and they get injured. I could see someone successfully claiming that was a state-created danger because the police officers told me to walk that way, and I shouldn't have been forced, essentially, to walk that way. I came up with this based on a case out of the Ninth Circuit from 2000. This guy was drunk at a bar, and the bartender called the police and asked the police officers to make him leave, which they did, but he didn't have a jacket, and the police officers told him that he couldn't drive home. And he ended up freezing to death outside. And his family was able to successfully sue because the family said, look, the police threw him out, they took his keys away, they knew what condition he was and he had nowhere to go. So the police essentially put him in that position, which seems a little silly because he was thrown out. Anyway, that's what the Ninth Circuit has said. You can't do a presentation about the Ninth Circuit and not make fun of them a little bit. So the fellow officer exemption is if a police officer sees another officer engaging in unconstitutional conduct in a protest situation or in any other situation, the Ninth Circuit has recognized that police officer has an obligation to stop that unconstitutional conduct. Think about the George Floyd situation. Couldn't present that scenario any more clearly. So you might also wonder, what rights do public employees have to protest? In general, public employees may attend protests in their spare time, just like anyone else can. The First Amendment protects public employees' right to speak as a citizen about a matter of public concern, as long as the speech does not interfere with their job duties. I'll give you an example of when speech might interfere with job duties. Imagine a doctor in New York City in April who attended a protest of the governor's stay-at-home order. It would seem like that, and he worked at a public hospital. It would seem that that might have been speech at the time that interfered with his official job duties. So another question that you might be wondering is, how could the governor allow protests that ban other gatherings due to COVID-19? So in early June, your governor said people have a right to protest, but at the time there was an executive order in place that disallowed people from gathering in groups of more than 25 for cultural, civic, or faith-based reasons. So here's a scenario where protest speech was treated differently, better than religious speech. But both of those speech, religious speech and protest speech, are protected by the Fourth Amendment. And remember what I said earlier, content-based restrictions on speech are almost always unconstitutional. Now, as far as I know, no one challenged the governor's executive order. But even if they did, despite my reservations, it's very likely that the governor would have won. Here's why. The governor of Illinois also had an executive order. He banned gatherings of people, of 50 or more people, except for religious gatherings. So the Illinois Republican Party objected and said, well, we want to have gatherings of over 50 people, and we're also protected by the First Amendment, just like religious speech is. So the Seventh Circuit said, well, you know, the governor didn't have to carve out an exception for religion, but it did. That was the governor's prerogative. But I still wonder, how could he do that at the expense of political speech? Well, ultimately, the Seventh Circuit didn't provide a good answer to that. But the Supreme Court allowed that executive order, which, like I said, essentially treated religious speech better than protest speech. The Supreme Court upheld it, as did the Seventh Circuit. So I think in this pandemic, the bigger picture point is not that the Supreme Court is necessarily clarifying the First Amendment in perfectly clear ways. I think it's more just the court has been sympathetic of state and local governments' desires to limit COVID-19 and has realized that they put some of these orders together quickly and that a lot of things have come up that weren't anticipated. So some of you may be wondering, if you read the president's executive order, or memorandum rather, about anarchist jurisdictions, which was issued in early September, if Portland is really going to lose its funding as a result of being labeled an anarchist jurisdiction. So Portland was labeled this way because it had, among other things, refused the federal government's assistance and had a series of significant protests. So what this memorandum does is it instructs federal agencies to look at taking away federal funds from cities. But here's the deal. It's Congress that conditions federal money that goes to cities, not the president, not administrative agencies. I do not know of any federal statutes that condition money to cities based on whether or not they are an anarchist jurisdiction. I never heard the phrase anarchist jurisdiction until this memorandum was issued. So I don't think that Portland necessarily has a lot to worry about. Another interesting question that has come up in terms of the protests in Portland is, can federal law enforcement be in cities? The short answer is yes, to protect federal property and to conduct investigations and make arrests without a warrant if there's reasonable grounds to believe a felony has been committed. But here's the deal. What people have argued in Portland, there's at least two lawsuits filed to this effect, is they said the federal government has said they've come to protect courthouses. But really, that's not what they've done at all. They have just arrested protesters for other reasons. And this is a violation of the statute, which only allows the federal government to do limited things, and a violation of the 10th Amendment that basically says all power that doesn't go to the federal government goes to the state government, which is basically most police power. These lawsuits are in their infancy. I do not know how they will turn out, but they are absolutely fascinating. Another question that has come up is, what about the Insurrection Act of 1807? This allows the president to bring in federal officers in the event of an insurrection. It's been used multiple times, but usually it's been used when the governor has asked for help. It does appear, if you look at the statute really carefully, that the governor's permission is not necessarily required, but an insurrection would have to be so serious that it would be impractical to enforce the laws of the United States, which sounds like a pretty high bar to me. So with that, I am going to thank you very much for your time and attention and tell you how sorry I am that I couldn't be with you in person. A good friend of mine recently asked me, if you couldn't live in Washington, D.C. and you couldn't live where you grew up, where would you live? And without batting an eye, I said, Oregon, of course. So I'm sorry I can't join you, but I hope you enjoyed my presentation and learned a lot.